Ladies and gentlemen, let me present to you Module 5, the Code of Conduct and Ethics. So for Code of Conduct and Ethics, the question is, why do we talk about ethics? Is it particularly relevant to the trust and fiduciary or asset management business? Can ethics effectively be taught to individuals, to corporations? So the most important part about the trust business is we want to make sure that we protect the trust customers. We want to improve efficiency. We want to, of course, expand our compliance efforts. We want to make sure that our shareholders are confident with regard to our operations. We want to, along with improve the efficiency, we want to enhance our productivity. And we want to attract and retain a certain type of quality about our workforce. So why is ethics so important in organizations? Ethics are the principles and values an individual uses to govern his or her activities and decisions. In any particular organization, a code of ethics is a set of principles that guide the organization and its programs, policies, and decisions for the business. The effective ethical philosophy an organization uses to conduct business can affect the reputation, productivity, and the bottom line of the business. So what are the statement of principles in the Code of Conduct and Ethics? The first is prudent administration. So accounts shall be administered in conformity with the intention and purpose of the client, as manifested in the agreement, with the skill, care, prudence, and diligence necessary under the circumstance then prevailing that a prudent man acting in like capacity. So effectively, when you are managing an account or caring for your client, you have to act like a prudent individual or a father taking care of his family. There should be undivided loyalty and utmost care, such that the interests of the client shall be placed above those of the bank or the corporation. Fiduciary assets shall be objectively and fairly administered, invested, and distributed, giving due regard to the beneficiary's respective interest. There is non-delegation of responsibilities, and trust responsibilities shall not be delegated as the client's confidence is reposed to the trust entity and not with any other entity. We have to preserve and protect property. There should be reasonable care and diligence that is observed, preserve to protect the property entrusted. So that's the whole reason why we do due diligence, why we undertake research reports, valuation reports, why we give investment reviews. We want to make sure that we are doing our utmost to preserve and protect the assets of the client. We want to keep and render accounts. So with this, you have to keep an accurate record of transactions. Likewise, material facts within the knowledge or reasonably discovered by the trust entity, particularly that would enable the client to make well-informed decisions, shall be transmitted or relayed to the clients for them to protect their interests. Fidelity is the cardinal principle common to all trust and fiduciary relationships. So all of these policies will be predicated upon fidelity and shall be directed towards the observance of the following. Number one, prudent administration. Accounts shall be administered in conformity with the agreement and the prudent man's rule, or the good father to a family. There should be undivided loyalty and utmost care. So the interest of the client shall be, again, placed above the bank or the entity. There is non-delegation of responsibilities. You shall preserve and protect the property of the client, and we shall, of course, keep and render accounts for the client. These practices shall be carried out in accordance with the basic standards and risk management guidelines as prescribed by regulations. The Trust Officers of the Philippines has a code of conduct and ethics, which was adopted last May of 1997. The aim of this code is for trust officers to conform to the highest standards of integrity and prudence in the performance of their trust and other fiduciary responsibilities. So what are the definition of terms under the TOAP Code of Conduct and Ethics? So a trust officer, it's just not the head, it's any officer or non-officer of the trust department who exercises discretion and judgment. This will also likewise apply to any trust officer acting as a fund manager who is engaged in all forms of administration of property or money and its equivalent for the benefit of the owner or a third person. Reasonable shall refer to what is proper, fair, just, moderate, and suitable under the circumstances. Self-dealing shall relate to transactions wherein a trustee may be acting for his or her personal benefit, and also as trustee which may give rise to conflict of interests. To define prudent man's rule, it requires the fiduciaries to manage the assets entrusted to them with the same care and discretion, as well as diligence as a person of prudence, good character, and intelligence who would handle his or her own affairs. Arm's length transaction, on the other hand, is defined as a transaction under which related parties, each acting in his or her own best interest, would carry out a particular transaction. The TOAP Code of Conduct covers the following relationships: the trust officer in society, the trust officer and the client, the trust officer and government and its agencies, the trust officer and the members of the trust and fund management profession, the trust officer and the member institution. With regard to the trust officer and society, there is a social dimension to financial business. By delivering trust, asset management, and fund management services, it should not be prejudicial to the public good, with loyalty consistent with what is moral, what is just, and what is legal. There should be a creation and promotion of public awareness of the different types of trust products and fund management services, and in particular, promote services that can contribute the most good for the greater number. We should also treat all accounts and/or clients equitably and fairly. With regard to trust officer and society, it stresses mutual benefit and satisfaction. We should refuse on moral or legal grounds to accept any business that could impair the good reputation of the institution and the association. Meaning, if you are asked to do something illegal or unethical, we should shy away. We should accept and retain accounts where trust and other fiduciary services can be rendered to the mutual benefit and satisfaction of all parties, provided that the proposed account and its objective is humane and conforms with all legal and regulatory requirements. The trust officer shall charge fees that are commensurate with the services rendered, or within the range as prescribed and/or authorized by management, which are based on the time spent that you manage the trust account, the extent of the business relationship. Does the client have accounts with your entity? How many accounts? What is the total assets under management? How many people do you require to manage the account? Is it an account that requires several personnel, or should one person handling the account be sufficient? What is the degree of difficulty and performance in handling the account? What are the responsibilities and risks inherent in the account? The difference here is that, is it a directed account or is it a discretionary account wherein there's a lot more decision-making that is required. What is the nature of the fund? Giving appropriate consideration where the fund is for benevolent or charitable purposes. For trust officer and the client, the welfare and interest of the client is paramount, characterized by care, good faith, and an arm's length with regard to transactions. The trust officer shall observe utmost fidelity to clients, fair deal for all accounts. We should administer the accounts primarily for the interest and benefit of the client and the latter's beneficiaries. We should deal fairly with all accounts. We should avoid conflicts of interest, such as self-dealing and self-servicing transactions. We should also keep confidential the records of the client, as well as any information acquired in the course of handling the latter's account, except, of course, when required or requested by such competent authorities. We should keep proper accounting and reporting on clients' investments. We shall submit a comprehensive report of fund and investment performance as required by the existing regulations. Allow the client full and complete access to all records pertaining to their account during office hours. And we should institute the appropriate controls for the administration and security of each fiduciary record account. In this account, the trust officer shall keep the trust books and records of each fiduciary account separate and distinct from the books and records of other business. Ensure that the trust books and records contain full information relative to each fiduciary account, and keep all the monies, properties, or securities received by the institution in its capacity as a trustee, fiduciary, or fund manager separate and distinct from the assets of the other businesses. The trust officer shall also make full disclosure to the client of all relevant information and details on the latter's investments and seek written approval for all transactions that require prior consent. In accounts wherein the trust officer exercises full discretion, the trust officer, in effect, shall ensure that safety of principal is primary. Income is only secondary. Make sure that we have a clear understanding of client guidelines, objectives, and restrictions. We should also comply with all terms and conditions and conduct business at an arm's length basis. The trust officer shall establish a clear and mutual understanding of the client's guidelines, account restrictions, and objectives, such as, but not limited to, capital preservation, liquidity, growth, investment, return optimization, and risk management. With regard to the relationship of the trust officer and the client, we should comply with the terms and conditions of the agreement or documents governing the trust and other fiduciary accounts in a manner consistent with the applicable laws, rules, and regulations of this code. We should refrain from engaging in any transaction which may actually or potentially give rise to a conflict of interest which may unduly compromise the interest of the client. The trust officer shall at all times transact its business in behalf of his or her clients on an arm's length basis. With regard to the trust officer and government and its agencies, the trust officer, we shall cooperate with the government and its agencies on matters relative to trust and fiduciary business. We shall, of course, show respect and fairness without violating the confidence and trust of our clients. We need to keep abreast of developments in relevant laws and regulations, including, but not limited to, securities, taxes, banking, financing, competitive industries, and developments affecting the trust and asset management industry. The trust officers shall also ensure continuing compliance with said regulations and procedures. With regard to the trust officer and the members of the trust and fund management profession, we need to uphold the integrity and dignity of the trust and fund management profession. We should support activities that shall promote the professional development of the TOAP members, which includes this one: Observe mutual respect, courtesy, cooperation, friendship, and professionalism with other members of the trust and fund management profession. Maintain healthy competition with trust officers of other financial institutions by refraining from practices such as misinterpretation of material facts, negative criticism, or derogatory remarks against competing institutions. A trust officer shall have the moral obligation to ensure that all advertising and promotional materials contain clear, factual, and full disclosure of the institution's products and services so as not to mislead clients. For the trust officer and the member institution, the trust officer shall of course observe loyalty to his or her institution. The trust officer shall implement the decisions of the trust committee of the institution he works for, provided, of course, that such decisions are not contrary to the existing regulations as well as to this code. All transactions with the institution made in behalf of his or her clients shall be carried out on an arm's length and best effort basis to uphold the independence of the trust and to primarily serve the best interest of the client. The trust officer, in coordination with the member institution, shall establish and enforce strict compliance with internal policies relating to interests. Utmost propriety shall be exercised by the trust officer so that he or she does not take advantage of his or her position and information or confidences relating to his or her work. The trust officer, in coordination with the member institution, shall observe the highest standards of integrity and honesty, and in coordination with the member institution, shall keep abreast of developments of skills needed for them to perform their duties and responsibilities to clients, such as continuing education developments. The trust officer, in coordination with the member institution, shall ensure adherence with existing regulations, this code, and the rules and regulations of TOAP. The trust officer shall inform his or her institution directly or through their immediate supervisors that they are obligated to comply with this code and is subject to disciplinary sanctions for violations. So what is the code? And the sanctions are the procedures prescribed by TOAP board and ratified by the members' quorum. If you are admonished, you are suspended for 1 month, and then expelled, you need the vote of 2/3 of the vote of the members. Any amendment to the code and modification requires 3/4 the vote of the membership. When a trust entity enters into any investment deal or service with its parent bank, any of its subsidiaries or affiliates, it must ensure that conflicts of interest are avoided by establishing and maintaining an adequate Chinese wall between them. This Chinese wall is a system of barriers between the trust entity and the bank and its related entities. This should consist of having separate policies and procedures on credit and investments for the trust entity, a clear delineation of duties and responsibilities pertaining to a deal or transaction. All deals undertaken by any trust entity with its parent bank or related companies must be in the ordinary course of business. This should be done at an arm's length in accordance with the best trading practices. So best execution, what does it mean? In conducting business activities, traders, portfolio managers, and fund managers shall act in the best interest of the clients, take all reasonable steps to execute client orders promptly on the best available terms under prevailing market conditions. When you select a broker to execute a trade, you consider the full range of the broker's services. And in relation to discretionary accounts and pooled funds, exert reasonable effort to ensure that the quotes or fees of the related counterparties are in fact competitive. We need to document all communication with counterparties or brokers, including the bid offer prices, to maintain the audit trail.
Continue. Personal investment policy. All employees are required to disclose their personal investment portfolios. That is, all trust employees. All trust officers shall adhere to the best trading and investment practices, bearing in mind, of course, that the interest of clients must always be placed first. When in doubt, covered persons should consult the Office of the Compliance Officer prior to seeking approval to effect trade of any security, prevent the violation of this policy. With regard to consumer protection, let us first define what a complaint is. A complaint is an expression if dissatisfaction relative to a financial product or service in which a response or resolution is expected. What are simple complaints? A simple complaint is where frontline staff solution or immediate explanation action can be rendered. A resolution is immediate if it can be resolved without the need rather, of a third party intervention. A complex complaint, on another hand, is wherein the complaint need further assessment, verification, or investigation with third party intervention. A request is an act of politely or formally seeking for an action to be rendered relative to a financial product or service. And an inquiry is an act seeking confirmation relative to a financial product or service. What is a consumer assistance program? Consumer assistance program is composed of capacity building, wherein we provide continuing education to all personnel on consumer protection laws, rules and regulations, as well as related policies and procedures. The customer assistance process is a way wherein we are able to safeguard the interest of and nurture its relationship with existing and potential customers. For complaints recording and data management, it is defined as being able to maintain a consolidated master register of all feedback complaints received by the trust institution. Risk assessment strategies are ways wherein we're able to identify and analyze any recurring or systematic problem and any weakness in the internal control procedure or process. Complaints reporting is a process wherein we are able to submit a complaints report to the bank's Client Experience Center and to the board. And the evaluation of the Consumer Assistance Program is a process where we can assess the performance of the personnel or business units assigned to manage or handle the received complaints. Thank you, and good luck on your exam.